Number
And welcome back to
7.
my channel where we are all crime, all black, all the time.
24 SC 004525. Xavier Rainier.
Your Honor.
Ms. Jones, is that your client?
Yes, Judge.
Mr. Marquez, are you representing the state?
I am, Your Honor.
All right, it's on the calendar for plea and arraignment. So bring out the defendant, please.
Judge, I also filed a motion for bond reduction on that one.
It's not listed on the calendar.
Because she put the calendar out before I filed it.
He has a,
She put these calendars out a long time ago. I filed it,
and Judge, I would, and with all due respect to Ms. Jones, I would ask to have that set on a calendar, specific calendar, so I can bring in the victim. The victim deserves to be here.
I filed it on November 20th, sent copies of it to everybody.
Does that include Mr. Marquez?
Yes, of course it does.
You said everybody. I don't know who that includes.
Well, it includes the relevant parties, Mr. Marquez.
All right, so
And the
Mr.
case manager.
Marquez, Ms. Jones is asserting to the court that she gave you a copy of her notice.
And if she electronically filed it, I don't doubt that at all. The only thing being, Judge, because it's set for a plea and arraignment, not necessarily a bond reduction. That's the only reason that I would ask for a particular date on that.
All right, so let's deal with plea and arraignment. And according to you, Ms. Jones, he already has a bond, correct?
He has a $10,000 bond, but the bond order reads $11,000. So yes, he does have a bond.
All right, as to indictment 24 SC 004525. We're here for plea and arraignment, Ms. Jones. What are we doing?
Waive formal arraignment under a plea of not guilty.
All right, so the court will enter a scheduling order. You will be notified of the next court date. Ms. Jones, I'm going to come back for the bond reduction and give Mr. Marquez an opportunity to reach out to the victim. So we're going to hear it today. We're just not going to hear it right now.
I hear it today? Okay.
Yes.
I understand. I was just clarifying, Judge.
Oh.
Let me say this as well. There is a non-complex case that should have already been transferred to this courtroom. I'm not sure why they're dragging their heels. That case number is 23 SC 191544.
Non-complex does what it does. Delay, delay, delay.
Well, it was already delayed when I picked up this case, and I've been in communication with them for a while, and I can't figure out why they haven't submitted that. And I'm concerned about that one because that one is a criminal damage to property in the second degree. The discovery I see in the file from the non-complex attorney suggests that it's a misdemeanor at best, and he's been in custody for quite a long time. You've been in custody since May of 2023? That's 2024.
Yeah.
He's been in custody since May 29th of 2024.
6 months.
And then he did some time on that case last
On the
year.
24 SC 004525 or on the 23 SC 191544?
He got picked up on the 24 case, Judge,
Okay.
and then he's also being held on that 23 case.
They never set a bond in the 23 case?
He has a bond, and that's been reinstated.
All right, okay.
And Judge, just so the court is aware, and there was an ex parte filed on the 23 case. So it was under judicial hold status for a little bit.
Right, and when I got the file, I met with my client, determined that that request had been made in error. It's been withdrawn, and so it's ready to come here. I'm not really sure what they're waiting for.
All right.
But there's been a lot of dragging their heels on that case.
You can look into that while we wait for Mr. Marquez to speak to the victim.
Okay.
Or have someone in his office speak to the victim.
Thanks.
All right, position number 8, indictment 24 SC 004916, Rodney Jackson. Who's representing the state?
Judge, that's Mr. Wittenauer's case. However, for purposes of this calendar, I'll make the announcement.
All right, so this is on for plea and arraignment. Ms. Jones, what are we doing?
Going to waive formal arraignment, enter a plea of not guilty.
All right. The court will notify the parties of the next court date.
Thank you,
The
Judge.
scheduling order will be put in place.
Thank you, Judge.
If nothing further, all parties are excused. Okay. So we're going to move to the final plea calendar, indictment 23 SC 186907. Marquisha Knox.
Judge, she is present today. I'll ask her some time just to go out and retrieve her.
All right. Let's go to position number 2, indictment 22 SC 185436, Jawan Gaston. I don't see Ms. Rondon, so we'll come back to that. Position number 5, indictment 24 SC 001933, Javion Outlaw.
Good morning, Your Honor. Camera back, yeah, Mr. Outlaw.
Is he present?
He,
Okay.
and Your Honor, this is on for final plea, and we have a negotiated plea. I was in the middle of completing paperwork when Your Honor came on the bench, so if I could finish.
Go
the
ahead.
Okay, thank you.
That'll.
Oh, okay. Not a problem. We have other cases.
Attorney General.
Go to position number 6, indictment 24 SC 001711, Beverly Range. Is Ms. Rondon? Okay. Let's try position number 3, indictment 22 SC 185439, Aquila Carter.
Judge, I'm going to try to get in touch with him. I expect him today.
All right, position number 4, 6,
Custody.
Tashawn Hodge.
He's in custody, Your Honor.
All right. Mr. Marquez, are you representing the state?
I am, Your Honor.
Okay.
Do you have any questions about that? No?
Is he just pleading to count one and y'all are not crossing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand?
Get a jail case. It's almost inevitable. And especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly because he was in 1C,
Yes, Judge.
but in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was, the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions granted, given by this court. Considering the fact of everything, I'm asking the court to set a bond.
Mr. Kendrick would stay, I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. There'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place, and the next day there's a dead guy in the parking lot. And that has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's, co-defendant Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
Okay.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Green.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but
Okay.
with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by a convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, just Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we will be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation at a bond hearing or at a sentencing hearing. Is your best forecast, with maybe one exception?
That's correct.
Okay. All right.
Thank you, Judge.
Thank you. Ms. Bumpus, want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that, because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that, that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the 2 cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those 2, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. Incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or
I will keep everyone in the loop.
Okay, thank you,
Okay.
Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here. All right, we're going to just figure out what's next, but we'll take a break. I just need to know what what is remaining.
Everybody else up, right?
Yes.
Yes.
Excellent. Thank you, gentlemen. Maybe we can,
Female.
she is? Okay. Do you want to, would it be helpful that the Ms. Kuykendall, we can't handle today, but I could tell her that and then you guys can take her down. I'm assuming that's complicated to have her up here. Okay, why don't you just bring her right to the door?
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay. Well, there are two officers who got shot.
Well, actually, there's only one who got shot. There's another
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot. Pose downsides of that.
He served 4th of 2013 and May 8th of 2022. This defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL stronghold or with making to the court. It's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either, and the recommendation would be 5 years to be served on probation.
All right. Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right. And have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand?
Yes, ma'am.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using
Y'all remember
this
is the same
slime,
attorney that
which I'm sure by
Glenville
now the
ordered
court
to
knows
buy
has
lunch
many different
for all the
meanings
attorneys. He
in
got in trouble for
different
something, and
contexts.
Glenville ordered him to buy
Mr.
lunch.
Farley
He
is
didn't
born
do
and
it
raised
at the
in the
time.
Cleveland
Glenville told him
Avenue
to do it
area,
by, so he
and
embarrassed the
he
hell out
does
of him in front of
exemplify a
everybody.
lot of the great
This is that
qualities of
attorney.
people of that area: his creativity, intelligence, tenacity, his bravery in taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again. And he's actually employed by a record label to be a handler for musical artists. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
The state didn't have any real special conditions, obviously, other than follow the law.
Okay. All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No, ma'am.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up, and that you're following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Ms. Jolly is on the way.
All right, Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right. Yeah, that'll be fine. And after you meet with her, then you are excused. Thank you. All right, are there any other guilty pleas that are going to be tendered today? All right, so what I would like to do is, and we can just start up here with Mr. Mender, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the four defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours. But this applies to you as well for everybody. This is the final plea date. It's your first final plea before me. I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to negotiate if you chose to, and have a final plea date, if you will. But this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, and you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, and that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it will be entirely up to the court to sentence. Could be above or below what any of the recommendations are, could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, ma'am.
Okay. All right. So, Mr. Mender, you have this case pending, and you have another case pending as well. Is that right?
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench at whenever convenient before we move forward with the final.
All right. So I will come back to y'all. So, Mr. Garlington and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor. Your Honor, on December 9th of 2024, the offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it'd be reduced to the lesser included offense of voluntary manslaughter, and him to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 all parolable time.
All right. And as a part of that plea offer, you all were going to null cross 40, 42, 43, and 51. Is that right?
That is correct, Judge.
All right. All right, and Ms. Rondelli, you discussed with your client the potential sentences that could be faced if he goes to trial and is convicted of all counts.
Yes, we've spoken extensively about potential risks of going to trial. I conveyed the offer to Mr. Darlington on December 10th, and we've had some discussions with Mr. Gotti since then. We are not in a position to accept the offer placed on the record. We will be rejecting that offer. I will state that there are further discussions that are taking place. We understand the court's admonition though about any of that.
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abadi, would you be able to put on the record
Plus,
you understand that, Mr. Let me say another thing as well. I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. The, I don't know, state's sort of story, theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all, that acquittals with a jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, you know, we've got a different prosecutor at the table who I hope would stay through the trial of the case. And it just is probably going to look a lot different. There's also a different judge at the beginning. So just keep that in mind. But I understand that for now, y'all will be rejecting that offer. All right, so we've got Mr. Eppinger, and I know Mr. Eppinger still has a motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the two attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those two videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just
Understood, Your Honor.
Mr. Eppinger, you understand that as well? Okay. All right. So, Mr. Body, can you put on the record what the offer tendered to Mr. Eppinger was, please?
yes, Your Honor. The state's offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent on this indictment. That sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
All right. All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr. Eppinger? Okay. All right. And was there something else you wanted to say?
No, I, just based on the circumstances, I came to the podium.
Okay.
Announcement. But given the state's offer, Your Honor, at this time, we would reject that offer based on our view and our view of the evidence in this particular case.
All right.
So yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right. Thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right. Not December though. Not that soon. Okay. So have we covered everybody other than Mr. Minder at this point? Yes. All right. So let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay. Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot.
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related
Okay.
to both, but the other witness is not necessarily important for the
Okay.
motion.
All right. So that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I'd think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay. All right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent and how you're acting in self-defense.
I mean, if he wants, whomever he wants to call, he can call. And I get that. So do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client
Okay.
after discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at sometime the week of January 13th.
It's fine with the state. If it's just the video, the state would stipulate to the video coming in, Your Honor, making a.
Okay.
finding.
All right. Did you, I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right. Let's do 10 a.m. January 13th.
I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay. Just making sure. All right. And then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want 1 witness, and it would be, we would need a production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear.
Cameraman petty as hell, because the lawyer that the cameraman keep putting the camera on in Burgundy, that's the one that they put gang charges on, because she
All right,
called.
and then I'll hear from Mr. Dark. But okay,
That's the
so
one
we're
they
talking
put gang
about
charges on.
Probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of
Putting gang charges on a lawyer is crazy. Wait, what happened? Oh, so that was the end of it? Okay. Well, that ended really ghetto. But Paige always ends court ghetto. Okay, well, cool. All right. Yes, they put gang charges on her. So from what I gather is it was a co-defendant. I don't even think it was this case. I don't know, but she went to the other co-defendant and basically told them to get rid of some shit on their phone. So that it wasn't her client, but it could help her client or whatever. So they put gang charges on her for conspiring with the gang. I'm trying to find it. Cavell, I don't really want to watch anybody else's stuff. Is Shannon's coming up next, or it was already done? Oh man, what happened to my? Oh fuck! Damn it! Sorry, I got some shit going on. How the fuck did I lose that? What in the world? Yeah, do you know if did Shannon already do it or is it coming? Fuck, how did I lose that? I really don't want to hear I really don't want to hear nobody else talking. I'm gonna put it up here for now and then I'm gonna try to find it on my own because I really just don't want to hear that extra stuff.
Plead guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone? Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm?
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea, or just a regular guilty plea. All right, so we're going to start with (22 SC 185532). The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends, or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, The next time you get a felony conviction, you're gonna be looking at a lot of years. And nobody's gonna say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572. So you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there. So there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet, that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you, or I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right. So at this time, is there anything else from either party?
Judge, just Mr. Sharp had recommended, I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right. If there's nothing further, then all parties are excused.
Thank you, Your Honor.
All right, Shannon coming home today. I know that's right, Shannon.
22 case.
So, Ms. Brown, did you hear what he just said?
Yes, Your Honor. Mr. Brown.
Sorry? Well, you know what? I'm sorry, but you didn't introduce yourself, and so I was just taking a stab at it. What's your name?
Seth Brown. 88 Seth Brown.
Okay, so what was wrong with me saying Mr. Brown?
You said Miss
No, I didn't. I said Mr. Brown. I just slide my words into each other sometimes, so. Okay,
I'm sure the president.
thank you. You can be
Hey, I didn't say it, so sure, it ain't on me. Let's get a little backdrop. Morehouse graduate, 2018, gets hired on 2019 as an assistant district attorney. Went up from $65,000 to $90-something thousand in a salary job. Good job. And then left Miss Love. Still in the office, but under the tutelage of one Adam Abate. Why is that important? Well, let me show you all the last time Seth Brown had an impact on the case. Y'all sitting back, y'all ready for this? It's a long video. If you can and you want to get the conversation going, hit that like button and we'll get to it.
Rodney Sturkey.
Good afternoon, Mr. Sturkey. Where are you from?
Atlanta,
And where do you currently live?
in Clayton County.
And have you always lived there?
No,
Where did you live on January 13, 2015?
I was standing up on Old Hickory Road by then.
Do you recall residing at an address 3424 Ruby Harper Boulevard in Atlanta?
Yes,
And how did you come to end up residing there?
a friend of mine,
Okay, who's your friend?
Bush.
Does he have a first name?
I don't know his first name.
Is that Bush a male or a female?
It's a male,
And how do you know Mr. Bush?
my mechanic,
You said he's a mechanic?
Yes.
Oh, okay. And how long have you known him?
years.
Years? Do you know him to be, in your knowledge, do you know
The families in a positive way, man. There's my cash up right there. You know, 100% of the proceeds will go to them. If you happen to be in the city that day, pull up on me, man. I'll take pictures with you. I'll chop it up with
Meriwether, thank you for your time, and you are excused. And y'all can approach.
I would like to believe, and y'all let me know if you agree or not, that we had an effect on him leaving Miss Love and Miss Hilton. Because he's now joined Atkins, who left Miss Love and Miss Hilton, to go join Adam Abate over there in major crimes. It's amazing how you could push somebody in front of the bus and act like nothing happened. Like I said before, and this is just a theory, I have zero proof, zero. Let me tell y'all, this is just theory, but I think a lot of y'all can probably agree with me. I think Miss Love started to set them cats up and let them get hit by that bus because it was a losing case. Ultimately, it all falls on finding Willis. Do not be surprised if and when the opportunity comes for Seth Brown to get up out of there and he decides to leave. Will we go and crap on Seth Brown right now? No.
for Mr. McMullen. And I went ahead when I was addressing the rest of the remaining defendants and let Mr. McMullen is the last opportunity.
Yeah, I'm sorry, he was trying to say something.
Yeah,
but I'm
no, go ahead. Go ahead.
Yeah, we're good.
Okay, this will be the final opportunity today to enter a negotiated guilty plea. And that would be a plea that both sides have agreed to a recommendation. And if the court accepts the plea that sentences to something outside of that recommendation, Mr. McMullen would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence that was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because of dissatisfaction with the sentence. I just wanted to make sure, and I know Mr. Dark, you've told that to Mr. McMullen already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abadi to please let me know what the state's offer was.
Yes, Your Honor. On the 8th of December this year, the state sent an email to counsel for the defendant where the state agreed, or the state's offer was the defendant plea to count 1, conspiracy to commit RICO, and then count 2, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parolable or parole eligible. It's my understanding that at this time, the defendant is not accepting that plea offer. So he'd be facing a mandatory minimum if convicted after trial of life and a maximum of life without the possibility of parole plus 20 years, Your Honor.
All right, and do you understand that, Mr. McMullen? All right, and as I mentioned before, the fact that there was an acquittal of certain of your co-defendants does not mean that there would be an acquittal in a trial before a different jury with, different prosecutors, different defendants, different defense attorneys. So it's a chance that you are taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you could only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor.
Okay, and we discussed some timing already in your absence when I had the rest of the attorneys here. And what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. And we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Your Honor, Mr. McMullen told me that he's in custody for the past few years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I I just was appointed, I cannot remember right offhand, but I know it was in the last 60 days, I think, 60 days or more.
Your entry was August.
August, yeah.
And that's a lot more than 60 days. That's more like 5 months.
August in the other case, and then in this case, it was in July 19th.
Okay, 5 months.
Some other case or something.
Right.
But Your Honor, as I was saying at the last court appearance, I just got the discovery on this case on, I think, the 11th. And I don't know whether these other matters.
And as I said to you at the last conference, you should have been able to get all of the discovery from the, oh, you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of all of the remaining co-defendants. So you're just going to have to spend your holidays getting up to speed.
You know, to be clear, I'm not asking for a delay. I'm just putting on the record the conditions under which I'm working, and I want to be effective for my client. I don't think that he should just be forced into trial just because, for whatever reason, an attorney was finally found for him after 2 years.
Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months, and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time. So use your time wisely. Mr. Abadi, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Yes, Your Honor. I believe it's everything, but I'm not, I want to make sure I'm 100%.
Okay.
Yes.
All right. So the other dates. Lost my place now. Lost my place. Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed. And any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th. And any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial. And sometime between January 17th and February 24th, we may, before that date, get the jurors into, we're envisioning them coming in to answer the jury questionnaires on tablets. And so that we've got an electronic version of their answers, and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in a courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody, and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you, Mr. McMullen, do you have any questions for the court? All right. Are you going to want a few minutes to talk with your client after this, or did you have enough time beforehand?
I wanted to follow up because he had a question when we started.
All right. Okay. All right. We're gonna go ahead and finish this, and then I'll give y'all some time to talk in the back. I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts. All right. So this hearing is out of close. Thank you.
Alrighty then, January 17th. Shannon coming home, yet we don't know. There's apparently a warrant for him that nobody knew about. So, other than that, that's about it for the updates.